SJC-13316, Terrence Marengi and others, v. 6 Forest Road, LLC.
Good morning, Your Honors. May it please the Court. I'm Dennis Murphy on behalf of the appellants. First, I'd like to appreciate that we're here on an interlocutory basis, which, if it weren't for that, we'd have to suffer dismissal of a time-barred claim in order to challenge it, the bond order. This appeal presents a straightforward issue of statutory construction. Under Chapter 48, Section 17, zoning decisions are subject to judicial review. Any person aggrieved by a zoning decision can file an appeal in court to get that review. And for direct abutters, like most of my clients, the law presumes aggrievement as a matter of law. In this case, the bond should be reversed because the amendment that was enacted last year doesn't expressly apply to comprehensive permits. That's supported by the plain text, the context, and the structure of the statutory provision at issue, 48-17. Now, before the bond amendment was enacted, Chapter 48-17 already had a bond. The bond was for subdivisions. It was mandatory and between $2,000 and $15,000. That's paragraph 7 of Section 17. It also already provided for an award of costs upon a finding of bad faith or malice. When the legislature amended Section 17 last year, it expanded the categories of zoning decision that are subject to the bond. It specifically added 3: special permits, variances, and site plan review. Subdivisions under paragraph...
How about site plans? Doesn't every 40B have a site plan?
No, Your Honor.
Almost every?
No, I would say some projects are subdivisions and they create lots with a subdivision plan.
How about this one? This had a site plan, right?
This, I believe, was a condominium, but the issue there is that the site plan review provision of the Salisbury bylaw was waived by the board at the developer's request. That's in the record. The way to square the amendment last year with the pre-existing text of Section 17 is to read it in context. So when the legislature added 3 new types of zoning decisions that are subject to a bond, it enumerated very specifically special permits, variances, site plans. Subdivisions were already subject to a bond. And so now you have 4 types of zoning.
You have the one that the legislature feels the most strongly about, that it's put the most oomph behind, is 40B development, because it's addressing our housing crisis. It's addressing communities that are trying to keep low-income people out of their communities. It's critically important. So we're going to have this bond requirement for fights about neighbors' variances and fights about neighbors' special permits, but not for the one that the legislature seems to care the most about. Isn't that odd?
Yes, Your Honor. It is a little odd. There is this quirk in that Chapter 40B, Section 21, does make comprehensive permit decisions appealable to court by any aggrieved person. That's in accordance with the procedures of Chapter 48, Section 17, the zoning statute. The best analogy to me is the other statute that is for the purpose of developing affordable housing. That's Chapter 40R, Smart Growth. And when the legislature put a bond in Chapter 40R, it did it very explicitly. It said that the bond is for 2 times the annual carrying costs plus attorney's fees minus any net income from the property during the period of delay of construction due to the appeal. Now, the developer in this case is asking you to read all of those words into the bond amendment under 4817 that has one word, just costs.
I think the cost issue. Go ahead. Sorry.
I mean, it seems like you're not really addressing Justice Kafker's question. You're moving on to how much. And I thought the question was about whether it makes sense to have the bond requirement under this new amendment not apply in the situation that the legislature cared most about, which was making a streamlined process for the ability to develop low-income housing.
Yes, Your Honor, and I think that there are many avenues that the legislature could have taken. It could have made comprehensive permits not subject to judicial review. It could have put a provision.
Well, let's not deal with what other things the legislature could have done, but instead deal with what they did do.
So,
Yeah, does it make sense to you? I mean, normally we construe statutes to avoid absurd results. And I think Justice Kafker's question really puts a fine point on whether or not the construction you propose is actually absurd, where Section 40B is supposed to streamline the process to get low-income housing approved. And you're saying in connection with that quick process, you don't have the bond requirement. But in connection with all other kind of non-low-income housing, you do have the bond requirement. And does that make sense to you?
it does, Your Honor.
Makes sense.
It does because when the so there are several different types of zoning decisions that are subject to judicial review under Chapter 40A, Section 17. In addition to the ones that provide for a bond, subdivisions, site plans, variances, and special permits, there are also, in addition to comprehensive permits, there are zoning enforcement appeals under Section 15. Those are subject to judicial review, but there's no bond provision. If the legislature intended to make everything subject to a bond, it wouldn't have enumerated 4 specific types. On the policy issue of affordable housing, my answer is that if there was a bond, as there is in 40R, adopted to 40B, it would accomplish that purpose. I will say that the act that in 2021, the Omnibus Act enabling partnerships for growth, that did not amend Chapter 40B, it only amended Chapter 40A. And so it's consistent to think that the bond amendment as part of that would apply to the 40A zoning decisions and not to 40B.
Even though 40B incorporates 40A.
40B is appealable under the procedures of Chapter 40A, Section 17, yes.
So can I switch you to the cost? Because I think I find more, your literal reading there raises more complications to me. So it says $50,000 to secure the payment of costs. I mean, I've never heard of a case that had $50,000 in sort of traditional costs before. So how do we interpret that?
Nor have I, Your Honor. And in fact, the case law is really thin on this because, frankly, as a practicing attorney, I almost never submit a bill of costs. It's not worth my time. And so the way to interpret it is the meaning of costs in paragraph 3, where they're subject to a bond, and in paragraph 6, where they can be awarded. They've got to be consistent. We've got to construe that term the same way in the same section of the same statute. So absent statutory authorization.
Okay, but then I get confused, and I'm honestly, I'm totally confused on the second part of this. So the costs, they're providing for $50,000 to secure the payment of costs. The costs that you described that require malice and bad faith are the kind you don't even file for, right? Because they're not worth your time and energy, right?
Generally, you're right, Your Honor, yes.
So we're going to allow 50,000, and this applies again into every little zoning case, every little You know, a lot of towns give, everything is done through special permits. So we're gonna have $50,000, much as $50,000 bonds for these type of cases. I'm just trying to make sense of this thing. You know, your view is you don't file for these things, but the legislature has provided for $50,000. Doesn't that suggest that they're really not talking about those type of technical costs? And they're not talking about bad faith and malice?
Your Honor, the $50,000 amount alone, particularly when you compare it to subdivision plans, when the bond for subdivisions was adopted, I think in the 70s, it's between $2,000 and $15,000. That's mandatory. The other is discretionary. I think it's meant to be an outside limit. I also believe that the strict interpretation of the word costs is really confined by the rules and the ordinary taxable costs for litigation items. When the legislature has a bond and it applies for extraordinary costs like carrying costs or interest or attorney's fees, it says it, and I've cited a few. I mentioned Chapter 40R, the Boston Zoning Code. That has an express provision that says the bond is to indemnify for damages. It says it very clearly. The word indemnify, the word damages. You shouldn't read the word costs in 40A-17 to mean indemnify for damages just because they happen to increase the amount from $15,000 in 1975 for subdivisions to now up to $50,000 in 2021 for other types of relief.
So why should we add cost tax, taxable costs? You're saying we shouldn't read these other things into the statute, but you're asking us to read in taxable into the costs that are allowable under this $50,000 bond, which I'll agree with you is outsized for taxable cost, but must mean something else given that it's not taxable.
I don't think you have to read in the term taxable in order to have costs have their plain meaning. They are defined under Rule 54, and there is a case cited in my brief, Styler, that actually says costs are to be interpreted
Yeah, but in that Styler case, which the author of which you may know, that was about taxed cost. It was not just about cost. It was a specific insurance provision that required the insurer to cover taxed costs, which is why I asked the question. Here, the statute did not see fit to say taxable cost. Instead, it said a number which suggests it's not limited to taxable costs.
Your Honor, the cost provision of 40A-17 was not amended by the bond amendment. That paragraph 6 of that section is the same as it's been for almost 50 years. And so I'm a zoning attorney for quite some time. I'm not aware of any case where there were costs awarded. I did cite the Sheehan case, which was the anomaly of some abutters in an appeal who, like my clients, are direct abutters, presumed aggrieved, and the court found below that there was bad faith, and the appeals court said that's inconsistent. How can somebody be presumed to be aggrieved with a right to judicial review, yet somehow that seeking that judicial review is in bad faith? And I think that a similar result should obtain here.
Isn't it possible to resolve the seeming inconsistency by setting the bond, requiring the judge to set the bond amount by considering the good or bad faith of the litigant?
Yes, Your Honor, and I was going to touch for a moment on that balancing test. In this case, there was no hearing, there's no written memorandum, we have no findings in the record, so we're left to try to guess what the balancing might be. The court has to consider the merits, the relative financial means, and then decide whether the burden on the plaintiffs to post a bond is outweighed by the burden on the developer from the delay. In this case, the $50,000 was reduced to $35,000. We don't know why. I think this is a civil matter. I believe that in the criminal context, the judge may have thought he was doing us a favor by reducing it. In fact, whether it's 50,000 or 35, the result is the same. It becomes an insurmountable hurdle without refinancing mortgages, and that's too steep a price to pay.
What can I'd just like to understand that a little better. So the bond, to get a bond of $50,000, I don't know, the criminal context, it's $5,000, right? What is it in the civil context? You're going to have to, you don't put up the whole amount, do you?
You do, Your Honor. We looked into this. It's not in the record, but we looked into this initially, and you've got to have $50,000, or in this case, $35,000, in order to make that surety with the court.
Meaning you have to secure it with $50,000, but you don't have to put up $50,000, right?
That's correct, Your Honor. But you have to have designated funds. It's not a 10% or 20% ratio. It's 100%.
And the funds have to be in escrow, or they don't have to be in escrow? And none of this is in the record, so I guess this is not helpful.
It's a brand-new statute, and you're asking a civil attorney who is not used to posting bonds. So my apologies. I actually don't know the mechanism, and I hope never to find out.
Okay, thank you very much.
Yes, thank you.
Okay, Attorney Silverstein.
Good morning, and may it please the court. Jonathan Silverstein for the private defendant, 6 Forest Road LLC. Your Honors, this bond applies to comprehensive permits because comprehensive permits are umbrella vehicles that encompass all manner of zoning relief. They encompass variances, they encompass special permits, and they most certainly encompass site plans. In fact, Chapter 40B, Section 21 requires or specifically references site plans. It says conditions may be imposed via the comprehensive permit on the site plans. The comprehensive permit itself in this case specifically lists the site plans that are included among the quote-unquote final plans that are approved by the comprehensive permit. And the comprehensive permit says this: this comprehensive permit shall be a master permit which shall subsume all local permits and approvals normally issued by local boards. Now, this court has previously addressed in 135 Wells what those local approvals are. And it acknowledges that it's all local approvals, everything from building permits to every other local approval issued by a local board. And local board is defined in 760 CMR 5602 to include planning boards. And under the Salisbury zoning bylaw, planning boards are the site plan approval authority. Now,
I'm going to, unless my colleagues have questions on this part, I'd like to move to what I find the most confusing part, which is costs. And I mean, is this thing is like a giant exploding bomb. If I'm just trying to make sure I understand it, because it's going to apply to everything: variances, special permits. If you challenge any of these things under, in the way you interpret it, which is without malice or bad faith, every time someone challenges something, they're going to have to get as much as a $50,000 bond.
no, Your Honor.
Okay, well, why not? Isn't that what it says?
Because this is a discretionary bond. Unlike the subdivision bond, this is discretionary.
Well, it's
the court
discretion, but a judge, someone can impose this, right?
can, yes, Your Honor. And
so-
you have to look at the purpose of this bond requirement, which is laid out both in my brief and in the amicus briefs that have been submitted to the court. And particularly, I would point you to the REBA brief and the Abstract Club, which lays out And also to the brief unprecedented, in my experience, submitted by too many amicus to mention, including DHCD, the implementing administrative body, Mass Housing. And what these briefs show is that in 2015, a report was done by the Mass Housing Partnership that identifies this terrible problem of not frivolous, not bad faith, but meritless land use appeals stopping housing projects.
I-
Go
and-
ahead, I'm sorry.
But I agree that I could see why the legislature would create this kind of powerful protection for 40B projects. But they don't. They may, but they start with, they apply the same powerful tool to all these little projects. So we have to read it, and you're sort of the afterthought. We have to do creative lawyering like you just did to get to comprehensive permits in 40B. But this bond provision, as written, applies to every little dispute that makes its way into the appeals court, the SJC, and everything else, right? It's just,
It can apply, Your Honor, and I see your point.
well, it's kind of scary that if my neighbor's doing something I don't like, and they're getting a variance or a special permit, I have to come up with 50,000. That's a kind of a,
But
that's kind of gonna shift and it's discretionary. And I don't know what
I take your point, but I do think it's discretionary, but it's not unbridled discretion. The court has to apply this balancing test. It has to look at the relative merits. It has to look at the harm to the public interest. I mean, it's very similar to the test for a preliminary injunction. It's not a slam dunk. And I respectfully, like Mr. Murphy, I've been doing land use law for 26 years. You're not going to have abutters arguing about dormers claiming the right to a $50,000 bond because they're not going to be able to meet the financial component of the test, and most likely they're not going to be able to meet the relative merits component of the test.
Well, it goes, if the court finds that the harm to the defendant or to the public interest resulting from the delays caused by the appeal outweighs the financial burden of the surety. Yeah. It's kind of open-ended, isn't it?
Well, but that, again, that's that one component.
Makes some sense in a 40B context,
It sure does.
but but again, it's also going to be applied to every little person's dispute with, and every variance and every special permit. It's like crazy.
Did the legislature paint it with too broad a brush? Perhaps, but that's a question for another day and another case that involves one of these, as you say, little cases.
So what is
but I do think we have to look at the
definition of cost then? So cost to you is what?
So cost to me would be what the balancing test refers to, which is the harm to the public interest or to the defendant. And in this case, that harm was supported by affidavit. And I do think we have to look at the remedial nature of the statute. And what I started to reference a moment ago, the MHP report comes out in the very next legislative session. This exact provision finds its way into a piece of legislation that passes in the House. And it takes, as these things do, a few years to finally get into this omnibus budget. But all along the way, a piece of legislation, all along the way, you see reasons proffered both by supporters and by legislators themselves. What is this about? This is remedial. This is to prevent situations where relatively non-meritorious appeals pause, raise the costs, and very frequently kill these projects.
Does it include a problem with the supply chain? Does it include a change in interest rates and things like that?
I would submit, and this goes to Mr. Murphy's, I'm not asking you to read in the specific language of 40R. That's very specific. This language just says harm. It says harm, and it doesn't say double the carrying cost, so I'm not asking you to read anything, I'm not asking you to read that in. It says harm. What is the harm to the public interest and to this
Well, if the-
specific
if-
developer?
If the affordable housing is going to go down the drain because since the appeal interest rates went up 3% and the supply chain's a problem because of the pandemic, so does that fit or not fit into costs?
I submit it does fit, and that's why the legislature had to put a cap on it, because that harm could be hundreds of thousands or millions. But instead, it capped it because there had to be some reasonable upper limit on what this harm could amount to and what these costs of this harm could be imposed upon plaintiffs for.
Is that harm limited by the good or bad faith of the appellant?
No, Your Honor. I mean,
You can award costs for delay, such as supply chain, et cetera, that Justice Loy is referring to, even though the party appealing was acting entirely in good faith?
well, I would submit that good faith and bad faith, it's a continuum, right? And the legislature tells the motion judge to consider the relative merits of the appeal. Here,
No, that's for setting the bond. I'm going to when awarding costs.
well, I would submit that setting the bond makes no sense if the costs aren't going to be awarded at the end of the day.
Right, but
If this is gonna be remedial.
What do you do with the statute provision that says costs shall not be allowed?
Right, that is a earlier passed general cost provision that does not apply to these costs under this bond provision. Clearly, the purpose, because if you're going to require bad faith, which is, I don't know how many cases this court has seen of bad faith costs being awarded. In my 26 years, I've seen it once. Now, if the purpose of the statute is remedial, as is clear from the legislative history, if the purpose is to deter non-meritorious, not bad faith, non-meritorious appeals, then what's the purpose of only allowing those costs to be imposed when there's a showing of bad faith? It would be pointless. There would be no point to the legislature of having taken 5 or 6 years after this report to impose this remedial provision if they were going to keep in this general requirement that you show bad faith to get those costs. It doesn't make any sense.
But the
And I think
legislature didn't excise that paragraph from 40A.
Well, they wouldn't, because that paragraph applies broadly to all types of appeals. This paragraph, paragraph 3, applies only to appeals from the grant of zoning relief. It doesn't apply to the appeals of denial of zoning relief. That still is governed by paragraph 7. It doesn't appeal to the grant or denial of zoning enforcement. That also would still require a showing of bad faith to get costs.
Conditions, if there's an appeal related to the conditions imposed, would that be covered? So, again, this may be a sort of an ignorant question, but if I've got a neighbor who, all in favor of 40B housing, but they didn't deal with, that the fire trucks can't get in properly, so I'm just appealing this because of the conditions, would that be subject to the bond?
It could be, Your Honor, because that would still be, you can't just appeal a condition. You have to appeal the grant of relief.
Right, so I've got some person who's worried about fire on their block. They all in favor of the 40B project. They just don't like that the way they've designed the road. So they're appealing, and they've got to now come up with $50,000 because this thing's going to make money. You got to satisfy those financial requirements. So it's going to be easy for the developer to show that they've got big dollars at stake here. So that little neighbor is going to have to come up with 50 grand.
But you still have to convince the court that the relative merits favor imposition of that bond. And that's not an insignificant requirement. That's why the legislature imposed that requirement, unlike in the subdivision bond requirement, which is automatic. Just briefly, Your Honors, I want to point out that the trial court was not required to hold a hearing on the bond requirement and clearly did consider the merits. And in my brief, I go through each of the elements of the test, including the relative merits of the appeal. And respectfully, the trial court had every right to rely on the fact that there were expert reports submitted both by the developer and peer-reviewed by independent experts retained by the board. And there was nothing but just conjecture on the part of the plaintiffs. And those relative merits are plain on the face. The plaintiffs complain about the fact that the board could have denied the comprehensive permit under a safe harbor, clearly not required to do so. And though some of the plaintiffs do have presumptive standing, we rebutted that presumption with these expert reports, and nothing was proffered to meet the plaintiff's burden of demonstrating that they do have standing. And for all those reasons, I think I submit that the trial court properly weighed the relative merits of the case in imposing the bond requirement.
Did you say standing
Yes, Your Honor.
butters?
They are abutters, which gives them a presumptive standing under the statute and under the case law, Standerwick, and all the case law of this court. That presumption of standing can be rebutted. We rebutted it by submitting expert reports from not just us, but from the board itself, and nothing but conjecture was submitted by the plaintiffs in response.
Thank you.